When a marriage dissolves, the court must untangle a complex financial partnership. If the parties are hostile, the dispute itself becomes a massive liability. Fighting over complex, contested assets generates out-of-control legal costs that actively deplete the very wealth the parties are trying to divide. To prevent this, the family procedure rules establish a rigid operational framework, beginning with Part 1. Part 1 defines the court's overriding objective, a strict mandate that cases must be dealt with justly, expeditiously, and proportionate to the money involved. Meeting this objective requires active case management. The court will step in to control the progress of the case, preventing either side from wasting court time and family resources. Achieving fairness is impossible if the cost of litigation destroys the financial resources first. To contain the dispute, the court enforces a rigid procedural structure. That specific structure is found in Part 9 of the Family Procedure Rules, which governs exactly how financial remedies are handled. This list of procedural steps outlines the specific milestones you will manage in practice, beginning with the Form E questionnaire and pushing through to the final hearing and consent orders. Think of the Part 9 timeline as a mechanical funnel. It takes a chaotic dispute and forces it into a controlled sequence. Mandatory disclosure nodes filter out the noise, isolating specific points of financial disagreement. The system is engineered with a specific aim, compelling a negotiated settlement long before parties reach the narrow endpoint of a costly final trial. Mastering Part 9 requires understanding how to use this procedural funnel to systematically exhaust the opposition's resistance and drive them toward an agreement. Before entering the funnel, parties must follow a pre-application protocol. This requires a mandatory mediation and information and assessment meeting, or MIAM, to attempt an early resolution. If mediation fails, formal court proceedings are officially triggered the moment the applicant issues Form A. Once initiated, the timeline immediately hits the bedrock of the financial remedy process, Form E. Procedural rules dictate that both parties must simultaneously exchange their Form E and file it with the court. Form E is an exhaustive financial statement. It requires a comprehensive accounting of all financial resources, current liabilities, and future needs, backed by documentation like payslips and mortgage statements. Because it dictates the rest of the case, it carries severe legal weight and must be signed with a statement of truth. The duty to provide full and frank disclosure is absolute. If a party hides assets, judges will impose harsh costs penalties or completely set aside a final ruling. Without the uncompromising transparency forced by Form E, the court has no accurate data to divide, rendering all subsequent stages of the funnel useless. Once disclosure is complete, the timeline advances to the first major hearing, the first appointment, or FDA. The FDA is an exercise in strict case management. The judge determines exactly what issues remain in dispute and decides if expert evidence, like a pension actuary, is necessary to value the assets. In January 2022, the Financial Remedies Court issued an efficiency statement that heavily updated how the FDA is managed. Historically, opposing legal teams wasted court time by submitting separate, conflicting schedules of assets, forcing judges to cross-reference duplicate paperwork. Now, the court mandates the use of joint documents. The first is Form ES1, a single, unified case summary and chronology drafted by both sides. The second is Form ES2, a master schedule of assets and liabilities. It utilizes 3 strict columns to display the applicant's view, the respondent's view, and the joint view side by side. By forcing legal representatives to collaborate, the ES2 structure isolates the precise mathematical disagreements onto a single shared canvas. If the parties successfully map out their dispute using these forms, they can utilize the accelerated procedure at the FDA stage. If both sides agree on draft directions and submit their ES1 and ES2 14 days before the hearing, the judge can approve the order on paper, completely excusing the parties from attending court. The efficiency statement acts as a procedural vice. It forces adversarial parties to synthesize and refine their disputes into a single, manageable dataset before they ever step in front of a judge. With the issues defined, the case enters the most critical phase of the timeline, the financial dispute resolution appointment. The FDR is not a trial. It is an active, judge-led negotiation phase where parties are legally required to use their best endeavors to settle the case. The core evidentiary rule driving this negotiation is that the FDR is conducted on a strictly privileged, without prejudice basis. This privilege provides legal cover. It allows parties to make frank, compromising offers without the fear that those concessions will be used against them in a future trial. The court drops a strict judicial firewall around this room. To guarantee the privilege holds, the judge who presides over the FDR is legally barred from having any further involvement if the case proceeds to a final hearing. But if the FDR fails to produce a settlement, there is an immediate procedural consequence under Rule 9.27a(1). Within 21 days of a failed FDR, the parties must strip away their privilege and file open position statements, formally declaring the exact orders they will ask the trial judge to make. The FDR is a highly engineered crucible. It offers a safe, protected space to settle, backed by the immediate threat of entrenched public litigation if the parties refuse to compromise. Following the FDR, the timeline splits into two final paths. The preferred path captures the negotiated agreement in a consent order. Practitioners use standard precedent drafts to present the agreement, ensuring the court can efficiently review and approve it. If the negotiation fails entirely, the case drops into the alternative path, the final hearing. To prevent trials from sprawling out of control, Practice Direction 27A places severe logistical constraints on the final hearing. The entire trial bundle is strictly limited to 350 sides of text contained in a single A4 lever arch file. This hard limit forces practitioners to ruthlessly curate their evidence, actively punishing those who have not properly narrowed the issues. The entire procedural architecture builds to this constraint. It takes the raw data of Form E, organizes it through the ES1 and ES2, tests it in the FDR, and distills it down to a single binder. Mastering Part 9 is about wielding these procedural rules to systematically neutralize disputes, protect the client's wealth from unnecessary litigation, and fulfill the overriding objective of the family court.